Just had your first child? Maybe you just had your third, possibly your fifth. In any case, you, as a parent, want to make sure you're doing everything you can to protect your children. But what most parents don't think about? What legal documents do you need in place to make sure your family is secure and protected if something were to happen to you? Now, I'm not just talking about a last will and testament. There are multiple things you ought to have in place once you welcome a new member to your family. I'll detail the 4 documents you must have in place to prepare your family if the unthinkable were to happen. Hi, I'm John Strohmeyer of Strohmeyer Law in Houston, Texas. I'm board certified in both tax law and in estate planning and probate law, and I've guided hundreds of families through the maze of estate planning, probate, and tax law to help them leave no unfinished business. I've also seen the tragic consequences of not having some or all of these documents in place. Now, in my other videos, I often use the analogy that a solid estate plan will protect you from the 4 horsemen of the estate planning apocalypse: loss of future assets, future costs, family frustration, and future fights. The documents I'll talk about serve as your armor against these 4 enemies in the case of your death, injury, or incapacitation. Let's begin. The first and most obvious is the one you're thinking about. Having a last will and testament means that people will know who gets your stuff when you die. You don't need to have manicured lawns and 7 Porsches for this to be something you need to have as a part of your plan. Not having a will in place only increases the time, costs, and frustration that will happen if you die without one. Document number 2 is just a list of all your assets. Think about this. If something were to happen to you right now, would anybody else know what you own and where you own it? So what we want you to do is get out a pad and paper and just write down, what do you own and where do you own it? This will help people find things if you can't be there to tell them where to find them. Document number 3 is a declaration of guardians for your minor children. If you're not here to care for your children, you should be saying who should take care of your children, both whom they should live with and who should be in charge of the asset that you'll leave for them. Texas law also gives you the option to exclude specific people from serving as guardian of your minor children if there's anybody who may want to be involved that you don't think is appropriate for your children. The 4th document to have in place is some sort of testamentary trust to benefit your minor children. Children under the age of 18 aren't legally allowed to own anything, so if you don't have some sort of structure, typically a trust in your last will, that will own assets for their benefit, then you're going to have to deal with a guardianship process. And this can cost tens of thousands of dollars over the time that your child is a minor to manage the assets for their benefit. By having this trust in place before it's needed, you're able to avoid that cost and still benefit your children with the assets that you'll leave to them. So these are the first 4 things you'll want to get in place. Everybody's situation is different and you'll need to tailor what you're doing and how you have this set up for your particular situation. I hope this has been helpful. If you're looking for other answers, please feel free to look around. Thanks so much for watching. If you've got other questions about this, go ahead and leave a question in the comments below. Also, don't forget to like, comment, and subscribe.